case briefs, and so much more. LSData's got what you're looking for.
In a case shaking the world of transportation and logistics, Cook Specialty Company and Machine Systems, Inc. confronted each other over the loss of a hydraulic press brake machine while in transit. The main bone of contention arose when the plaintiff, Cook Specialty Company, claimed that the delivery contract became invalid as the defendant, MSI, did not take upon itself to ensure appropriate insurance coverage for the shipment. Notably, the crux of the argument was around the Uniform Commercial Code regarding risk of loss, which both parties agreed as the basis for settling their differences. Setting the legal backdrop, the case evolved when MSI clinched a deal with Cook Specialty Company to provide a Dries & Crump hydraulic press brake machine. Disarray struck when the machine, during transit, mysteriously disappeared. This instigated Cook Specialty Company to initiate a lawsuit, seeking recompense for their lost machine. To resolve the conflict, the court was handed down the task of reviewing the plaintiff's motion for summary judgment, along with the defendant MSI's countermeasures. As the gavel struck the stand, the court was set to decide a motion for summary judgment. A complicated process, it required the court to sieve through intricate layers of pleas, depositions, affidavits, and other such legal documentation. The ultimate aim was to pinpoint any factual discrepancies that could affect the course of the ruling. Despite the complexities involved, the two conflicting parties found a common ground in the Uniform Commercial Code's risk of loss provisions. However, it became evident that the risk of loss does not automatically transfer to buyer once the shipment is in the hands of the carrier, as per Section 2(504) of the Uniform Commercial Code. It also brought to light that the seller's onus is to arrange for a reasonable shipment contract, but this did not necessarily include obtaining insurance. Further investigation revealed that the contract in dispute was F.O.B, meaning it was the seller's responsibility until it reached their warehouse. Final judgment saw the court steering towards the defendant. The UCC, the court observed, crafted mercantile symbols to indicate transaction risks, and ultimately it was the party's responsibility to ensure shipments. Given that the existing contract was F.O.B, it became clear that the risk of transit loss rested on the plaintiff. With no conflict in the significant facts, judgment was granted in the favor of MSI. Thus, the legal duel concluded, leaving a lasting impression on merchants, insurers, and carriers alike.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.